Hey everyone, welcome to our fifth lecture, the Bill of Rights. There would be no constitution without those first 10 amendments we call the Bill of Rights. For context, the Constitution's ratification was wavering. The framers of our Constitution split themselves into two groups, the Federalists and the Anti-Federalists. The Federalists were pro-Constitution and believed in a big national government. Then you had the Anti-Federalists, who believed that states should reign supreme. The last true way to ensure the Constitution would be ratified was to ensure protections for the people from the government. And that's what the Bill of Rights is, protections you have from the federal government. There was hesitation to include it within the Constitution because many states already had their own Bill of Rights at the time. Federalists argued whatever is not stated in the Constitution belongs to the people. And if we included some rights, wouldn't this then imply that these are the only rights people have? And Anti-Federalists said, no, we want you to spell out what rights people are guaranteed, but we also want you to write, we have more rights guaranteed than the ones we told you to spell out to guarantee. Once again, it's all about compromise. So Madison, I imagine looking exactly how he feels, goes to rewrite the Constitution. And Federalists say, no, we already approved of the language. You can't redo it. So Madison says, fine, I'm amending the Constitution at the end to include people's rights. So these are our 10 protections from the federal government. The Bill of Rights went its first century without any controversy. Then came industrialization, and government and the individual became more entwined. As technology, capitalism, war, and culture changed, government started to provide more resources and regulation to our everyday lives, and we needed clear directions and boundaries on what the Bill of Rights did and didn't cover. For these directions, we rely on the Supreme Court for judicial review to interpret the Constitution and our relationship with the government. The Supreme Court, the highest court of the land, is part of the judicial branch. It's made up of 9 individuals, and they have the final say of what's constitutional, aka what the government can and cannot do.
The 9 of us are now a family. And we're a family with each of us our own burdens and our own obligations to others. But this is our work family. And it's just as important as our personal family. We probably spend more time with each other than most justices spend who have spouses with their spouses.
No amount of time we have will cover the complexity and interpretations of the Bill of Rights, but I'll do my best to give an overview, the current interpretation, and the controversy of each. Each court case, by the way, most likely went to a lower federal court or appeals court first before it gets to the Supreme Court. So when I say this person took their case to the Supreme Court, it had to go through other courts first. The Supreme Court is not like a liquor store just waiting for customers to show up. They're busy people with things to do, unlike Delaware. So let's start off with a classic yet fantastic, the First Amendment. These are a few rights packed into the First Amendment. It's the casserole of amendments. It guarantees freedoms concerning religion, meaning no government should enforce a religion upon you or prohibit you from practicing your own. We call that the Free Exercise Clause. We have freedom of the press, the newspaper, media, and the right to peacefully protest and to write petitions and altogether complain to and about the government. It's why the president can tweet something like, "We must keep evil out of the country," and Chrissy Teigen can tweet back with, "What time shall we call your Uber?" We also have freedom of speech, but a few things you should know about freedom of speech. It includes the protection of hate speech. It's how Westboro Baptist Church can go to funerals with hateful, outrageous signs. However, simply because you're protected from the federal government does not mean you are protected from your employer, your school, or stepping into any business.
The increasing intolerance and suppression of the time-honored tradition of free expression on our campuses jeopardizes the liberties of every American.
So when people say, "What? I thought this was America, freedom of speech. I can say what I want." Yeah, from the government. You can still get fired or kicked out or both. The debate is, What's not protected? A few things. While hate speech is protected, speech inciting violence is not. A notable court case for you, Shank versus the United States. Chuck Shank, self-proclaimed socialist, claimed the World War I draft violated the 13th Amendment and was a form of involuntary servitude. So he sent out 15,000 flyers saying to dodge the draft. Chuck Shank was caught and charged with trying to sabotage the US military. Chuck Shank said, "Hey, it's a free country. I could say whatever I want." So the question was, can Chuck Shank say whatever he wants? The Supreme Court ruled, heck no, especially in times of war. Certain rights and liberties are limited during times of war, and Chuck Shank's actions could potentially create a danger to the United States and people by saying, dodge the draft. What this court case did was say that speech creating a clear and present danger is not protected by the First Amendment. For example, yelling fire in a crowded room or bomb on an airplane.
What's wrong with saying bomb on an airplane?
You can't say bomb on an airplane.
Bomb, 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 bomb.
If it intentionally creates danger, you can be charged and convicted. Should we talk about porn and Red Bull today? Let's give the people something to look forward to in the future. Now, the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The right to own firearms. Now, the part that is debated comes down to collective rights versus individual rights. Most liberals in the United States believe the Second Amendment was talking about collective rights and focus on the well-regulated militia part. Conservatives, on the other hand, focus on the right of the people and believe it is the individual's right to own a firearm. The Supreme Court rarely takes on Second Amendment cases because they believe it should be left up to the states. However, a court case in 2010 changed a portion of that. McDonald versus Chicago. Old McDonald lived in a neighborhood that became more dangerous as the years went by. He moved there in 1971, and by 2010, McDonald claimed his neighborhood was overrun by theft and gangs. At one point, his house was broken into by his own neighbor.
I have a strong drive to do what I can to right that I see is wrong.
Chicago had a strict handgun ban, and when McDonald wished to purchase one, his lawyers made the case that the individual's right to a firearm not only applies to being protected by the federal government, but also protected from state and city governments too.
The senior citizens and law-abiding citizens like myself is being victimized by saying that you can't have a handgun in your own home. Why? Tell me what I can't have in my own home. I'm not out there robbing nobody.
So the question was, does the Second Amendment also apply to local governments? The Supreme Court ruled yes. So what it did, the Second Amendment's right to keep and bear arms for self-defense is also applicable against states and local governments. You have the right to protect yourself from not only federal government, but also state and your city government too.
Justice Samuel Alito wrote for the majority that gun ownership was an American's fundamental right. Chicago's handgun ban was lifted, and McDonald, along with the citizens of Chicago, could purchase handguns for self-defense.
Dissenters held firm in their beliefs that local government should be able to wield powers within their boundaries as they see fit.
They argued that the Second Amendment did not include a general right to private self-defense, and also that the Second Amendment should not be considered a fundamental right for purpose of incorporation.
The Supreme Court's ruling led to a reevaluation of multiple local and state gun control laws. It's clear that gun ownership remains a divisive issue in our country.
The Third Amendment. No soldier shall, in times of peace, be quartered in any house. This one goes without controversy. It was intended to keep British soldiers out, but it gives an implied right, and that is the right to privacy, and we'll come back to that later with the Ninth Amendment. Now the Fourth prohibits unreasonable searches and seizures. It should protect against arbitrary arrests, stop and frisk, wiretaps, and it should ensure probable cause and search warrants. The debate is what counts as probable cause. My court case is from 1914 regarding Weeks versus the United States. Old Fremont Weeks was selling lottery tickets through the mail. Police got a whiff of this and went to his house. Some nosy neighbor told the police where to find his house key. The police go inside and find evidence that he was mailing lottery tickets. But They had no warrant, and the Supreme Court said, without a warrant, you have no case. Unlawful arrests. Now that was a century ago. Today, while probable cause needs approval from a judge about what rooms and spaces police specifically look into, there's also reasonable suspicion.
He was holding me, he was going through your pocket, he was going up, down.
You want to go to jail?
For what?
Shut
for
your
what?
mouth, kid.
What am I getting arrested
Shut
for?
your mouth.
What am I getting arrested for?
For being a mutt, you know
Oh,
that?
so that's a law? Being a mutt? He was going through my sweater. Then that's when he told me to keep my hands on my head. So I was like this the whole time.
Frustrated by how often he was being stopped in his Harlem neighborhood, a 16-year-old son of a cop named Alvin says he hit record on his iPod one night in 2011.
Why you push me out for?
As two undercover officers approached.
Our job is to look for suspicious behavior. When you keep looking at us like that, looking back.
Cause y'all always like stop. I just got stopped like 2 blocks away. Like,
listen to me. When you're walking the block with your hood up and you keep looking back at us like that, bro, you think you might have something.
And reasonable suspicion is a blanket term for anything. If you drive too fast, if you drive too slow, if you're not compliant with police, all have been defenses used to search you under reasonable suspicion. The conduct of police depends on the region, the city, the state, so just be aware if you are confronted by a police officer, the best thing to do is to say nothing, which leads us to the Fifth Amendment. It prohibits self-incrimination and double jeopardy and mandates due process of law.
I plead the Fifth.
You don't have to testify against yourself. Double jeopardy, if you're found not guilty, you cannot be tried for the same crime twice, even if new evidence shows up. And you cannot be deprived of your life, liberty, and property without due process of law. You can't just be arrested and have your belongings taken away from you. My court case in 1940, Chambers versus Florida, a man was murdered in Pompano Beach, Florida. Police arrested 4 black men, put them in separate rooms without legal counsel, without contact, without charges, and questioned them for hours, sometimes up to 10 officers in the room with 1 man. Eventually, after previous denials, these 4 men confessed, then were charged and convicted and sentenced to death. But then, Thurgood Marshall, young black lawyer at the time, said, "Hold up. These young men had no legal counsel and were deprived due process of law." He fought for them all the way up to the Supreme Court, where he won his case. The men were released. Thurgood Marshall goes on to win many more cases and becomes the first black Supreme Court justice. But more on him later. The debate is, does procedure get in the way of justice? The tactics used in the Chambers case were common. Then Miranda versus Arizona changed everything. In 1963, Ernesto Miranda was charged of kidnapping and raping an 18-year-old woman. The woman identified him, and after 2 hours of questioning, Miranda confessed, but Miranda was never informed that he could have legal counsel. The Supreme Court ruled Miranda could not be convicted based on his own testimony, and he must be read his rights. This case was incredibly controversial and changed policing as we know it. Our Miranda rights, you have the right to remain silent, you have the right to an attorney, those rights came from a convicted rapist. He was charged and convicted by witness testimony later, and upon his release, just 5 years later, he would sign autographs on people's individual Miranda rights cards. By 1973, he was killed in a bar fight, and on his body, in his belongings, were plenty of Miranda rights cards. And that's where we get our Miranda rights. The Sixth Amendment. The right to a lawyer, a public trial without arbitrary delay, and to know what you're being charged for. The debate here, what's considered fair? If you're wealthy, you're going to have a different case than the person who has a public defender. Gideon v. Wainwright. Florida man Clarence E. Gideon, wild blonde hair with glasses, was a drifter, a lone wolf who got through life by taking what he could. Gideon broke into a pool hall, broke into a vending machine, and was caught. Florida charged him with felony breaking and entering and did not give him a lawyer. Gideon represented himself. He was found guilty and sent to state prison.
I'm sorry, but this court cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint a lawyer to represent a defendant is in a capital case. That is a case involving the death penalty.
The United States Supreme Court says I'm entitled to counsel.
Ms. E., would you let the record show that this defendant has requested the court to appoint counsel and that this request has been denied? Have your seat in the courtroom, Mr. Gideon.
Reading up on his own case in prison, Gideon actually wrote to the Supreme Court citing he believed Florida violated his Sixth Amendment rights. Does the Sixth Amendment's right to counsel extend to state courts? The Supreme Court ruled, yes. No matter your felony or lack of money, the state should supply you with a lawyer. This caused at least 2,000 individuals freed from Florida alone, and Gideon had a second trial and won his case. The Seventh Amendment, the right to a jury in civil cases. In federal cases, as part of a check on the judicial branch, the people have a say. It's why we have a jury. We are part of the law and order system too. The debate is what counts as a civil case. We got civil and we got criminal. A civil case is one that has a person or people in conflict with a business or entity. A court case for you, Feltner versus Columbia Pictures. This local TV station owner, C. Elvin Feltner Jr., would show repeats of Columbia Pictures shows like Who's the Boss and T.J. Hooker. Feltner did not have license to do this. A judge ruled that he should pay Columbia Pictures $8 million in damages. Feltner took his case to the Supreme Court, saying there was no jury involved, and this is a conflict between a business and himself. Where is his jury? The Supreme Court said, Feltner is right. He deserves a jury. So his case was tried again, the jury found him guilty, and the jury claimed he had to now pay $30 million. The Eighth Amendment, no cruel, unusual punishment or excessive bail. It prevents torture and high costs for jailed persons. The debate with this one is what's considered cruel or unusual. It's largely left up to the states. It's why we have capital punishment in some states and not in others. My court case is Atkins versus Virginia. 18-year-old Daryl Atkins and his friend robbed and murdered a man. The police discovered it was the two men. The friend blamed Daryl Atkins. Atkins' story kept changing, and he was charged and convicted and sentenced to death. But Atkins had an IQ of 59. The question became, is sentencing an intellectually disabled man to death cruel and unusual punishment? The Supreme Court ruled, yes, it is, and his friend and him were given life in prison. Now, the 9th and 10th Amendments are meant to be the catch-all amendments for anything miss. The 9th says people have more rights than the one stated. For example, the right to privacy, such as the right to make choices with your own body, such as the right to an abortion. Which brings us to the most controversial type of court case, abortion. In federal courts, they claim there are two types of cases, abortion and everything else. The case that changed everything was Roe v. Wade. Jane Roe, real name Norma McCorvey, was pregnant with her third child and wanted an abortion. She was denied by the state of Texas and later referred to two Dallas lawyers, Linda Coffey and Sarah Weddington. I say their names because in my humble opinion, they are the real stars here. Roe's case argued that Texas abortion law at the time, which stated abortion is only acceptable if the mother's life is in danger, was a violation of the First Amendment, Fourth Amendment, Ninth Amendment, and 14th Amendment. Women should have the right to privacy in determining the choice whether to have an abortion. The debate was, does the Constitution recognize a woman's right to an abortion? The Supreme Court ruled yes. Due to the 14th Amendment's due process clause, a woman's right to choose falls in their right to privacy.
We must link arm in arm to protect and uphold the right to safe and legal abortion.
Lastly, the 10th Amendment. Other rights and powers are for the states, meaning anything not stated in the Constitution belongs to the state. This is the States' Rights Amendment. My last case for you is Bond versus the United States. Carol Bond discovered her husband was sleeping with her best friend. When she found out her husband impregnated her friend, Bond tells her friend, I am going to make your life a living hell. So Carol Bond works at a lab and starts taking chemicals from the lab and starts putting them on her friends' doorknobs, on her car doors, and even on her mailbox. Her friend suffers a chemical burn on her hand, and Bond was indicted for violating the Chemical Weapons Convention Act. The Supreme Court said you can't apply a federal convention act on an individual. It should be left up to the state's police power. And applying the Chemical Wars Act treaty does not cover an amateur attempt by a jilted wife to injure her husband's lover. Our Bill of Rights are filled with cases, stories equally fascinating and horrific, and while we only covered a few this time, it's these individual stories that help determine the rights to us all. Even if something isn't explicitly stated in the Constitution, it's the change in our society that has opened up changes to interpretation of our rights. The last thing I want to stress about these views is whatever the Supreme Court does, it can undo. New cases challenge the ones before. It's why Roe v. Wade and abortion access is always being threatened by federal court. But it's also how federal law determines segregation is unconstitutional in Brown v. Board of Education. For better and worse, the rights we discuss today can be expanded or restricted tomorrow. But it's these first 10 that provide individual opportunity and liberty today. Thank you for watching. Godspeed.